It was submitted before this court that the appellant is a reputed doctor who is aged 96 years and the premises in question is about 2000 square feet, which is part of a larger plot of land which the appellant intends to use for construction of a hospital for charitable purpose staff. Looking at the laudable object, we adjourned the matter several times to enable the parties to settle the matter staff. In spite of our persuasion, the respondents' tenants were not willing to accept monetary compensation for evicting the premises and relocating to another site staff. The respondents contend that they will lose their livelihood if they are evicted from the premises staff. Having no other alternative, we kept the matter for decision on merits staff para. There are two submissions that are made on behalf of the appellant staff. The first point relates to non-payment of outstanding rent staff. The counter affidavit filed on behalf of the respondents was referred to submit that the arrears of rent from 1/4/1993 to 31/8/2009 was paid only on 24/9/2009, which would amount to non-payment of rent, which is a ground for eviction staff. We are afraid that we cannot agree with the submission made on behalf of the appellant staff. It is clear from the judgment of the rent controller that the arrears of rent were paid for 3 years prior to the filing of the eviction petition staff. It is also clear from the judgment of the first appellate court that the appellant did not assail the findings of the rent controller on issue number 1 pertaining to default in payment of rent staff. We cannot permit the appellant to make submissions for payment of default of arrears of rent at this stage staff para. The main point urged on behalf of the appellant is that the premises which was let out for sawmill is now being utilized for the purpose of manufacturing of grills which amount to change of user staff. Submissions were made before us by both sides on the interpretation of terms of the rent agreement staff. On a perusal of the agreement, we are convicted that there is no restriction placed on the respondent's tenant to run business only relating to the sawmill staff. The tenant was given the liberty to carry on any other business as well staff. In the absence of any negative covenant, the user does not amount to user for the purpose other than for which the premises was leased within bracket Mohan Lal versus Jai Bhagwan, 1988 under bracket 2 SCC 474 bracket out staff. A premises taken on rent for sugar cane crushing was used for cloth business, in which case the landlord's contention that there was change of user was rejected within bracket Dasarth, Babu Rao, Sangale and others versus Kasi Mat Bhaskar Data, 1994 supplementary under bracket 1 SCC 504 bracket out staff. We agree with the judgments of the courts below, which are in accordance with the law laid down by this court staff para. In view of the aforesaid findings, we see no reason to interfere with the judgment of the High Court staff. The appeal is dismissed staff. No cause staff.